Yes.
Permitted to mention one matter, my lord. Due to incorrect name in the FIR, I am unable to surrender before the appropriate court, my lord. Two of the petitioners have already been surrendered, but my wife is
How
unable
can
to
you
surrender.
correct your name in the FIR?
Not FIR, my lord. The Aadhaar card is there in the petition. Allies, I think, my lord, the cost title will.
I don't know what you think. But we have given you, take out your application, we'll consider. All right.
May I have your lordship that you will mention this bail in connection with appeal, my lord, more than 20 years.
For relaxation.
More than 20 years in jail. Brilliant. তোমায় বলছি না 14 বছরের উপর যে কটা লোক জেলে আছে অ্যাপিল গুলো একটা টুই মেনশনটা লাগাও না
Your Lordship, kindly inclusion of the matter in daily list, heading bail in connection with appeal.
Bail in connection with appeal.
Yes, call the list.
Item 1.
Correction, there is no. Next.
Item 2.
Further report we call TCR along with report be placed on record, adjourned 4 weeks. Yes, Mr. Bapuli.
My lord.
I have
Effect.
My lord, I have done a mistake, my lord, although law court record is not here. I have filed, my lord, 2 suspension of sentence. One I am withdrawing, my lord.
One will fail, the other will succeed.
Effects are both will fail.
Kindly.
Both will fail.
You will.
One as not maintainable, another on merit.
2 is not maintainable.
One on merits rejected, 2 on merit.
Same thing happened with us also. My lord, Sujit Jatri, Sujit Barman.
Sujit,
That Falta case, both of us filed.
No, I have filed also 2.
but it was a pleasure appearing before justice.
Yes. Yes, PP.
And
But I am not.
Yeah.
My lord, can two, my lord, can two is my lord not press, my lord. Great. Oh, beautiful.
Item 5.
My lord. Item 5, my lord, I am for the petitioner led by Mr. Dashma Patru.
Yes.
My lord, I am for the de facto complainant.
My lord, 420,406, my lord, the allegation against me is that I have taken 2 dumpers and I have paid only 4,50,000. My contention is that, my lord, there was only 1 dumper. On the last occasion, my lord asked me that how much money I have paid. I have taken the instruction, my lord. I have paid already 8 lakhs, 4,50,000 at the time of taking the dumper, and remaining 3,50,000 after that.
My lord, order dated January 10, 2025, paragraph 4 not complied. My lord, two dumper. My lord, lordship, one thing, my lord, that every day, my lord, recovery agent, my lord, knock my door, my lord. Lordship kindly recovered, my lord, two my lord, dumper. I am not
Saying that he has taken 1 dumper, you should.
no, my lord. Already, I have, my lord, deposited all paper to the investigating officer.
My lord, the state was directed to serve a report with respect to the second agreement. There was a second agreement, and my lord, they had only paid 1,50,000 with respect to the second dumper, and they were also supposed to pay the remaining installments, which they have not paid.
What is the outstanding now?
Outstanding 33 lakhs, my lord, to the my lord finance company, my lord. And every day, my lord, recovery agent has come to my house, my lord. Lord, I am paying for only.
Value of the dumper.
Yes, my lord, that dumper only produced, my lord.
Hear us. What is the value of the dumpers?
Value of the dumper, my lord, in fact,
1 dumper has been recovered.
no, nothing.
My lord, they were
Where is
directed to return.
one of the dumpers?
My lord, my instruction is that the 1 dumper that my client taken from him is not presently in his possession because
All petitioners submit that he has, petitioner submits that he has paid substantial sums to the de facto complainant as against the value of the dumper which had been let out to him. He denies the value of the dumper let out to him. He strongly refutes the allegation that a second dumper had also been let out. In light of the aforesaid submission, we called upon the state to submit report whether a second dumper had been handed over to the petitioner or not. Report is placed on record. Having considered the materials on record and the submissions of the parties, we note 2 dumpers had been let out to the petition. It is true initially some payments were made against the said dumpers. Thereafter, petitioners stopped making payments and none of the dumpers have been recovered as yet. Custodial interrogation for recovery of the dumpers is necessary. Under such keeping in mind the nature of the crime, keeping in mind the aforesaid facts, we are not inclined to grant and switch. Centered here. Next.
6. My lord, item number 6, my lord, we have for the state.
Sir, I am for the petitioner.
These are the report your lordship will have inquired for. Wherefrom, my lord, your lordship will find the first drug license, which is genuine, and other 2 is not genuine.
If the first drug license is genuine, then he has a genuine drug license. What are other two are not?
Other two, because the selling matlab the business house and matlab the procuring the drug.
And to tell us that those are not licenses, sir. Those are not licenses.
The report is there. That is what I am placing before.
To, if an insensitive police officer asks you to say something which is atrocious.
No, this is the drug controller.
All right. And where is the license? Where are the other two licenses? These are invoices.
Lordship, license is at page 13 and 14.
13 and 14. Yes.
অনলাইনে দেখানো গেছিল আগের দিন যখন
এইটাকে জেনুইন বলছে।
এটাই তো সেটা ঠিক।
What about the invoice? Do you understand what you are supposed to do? You know what is the case, what is his defense.
Well,
now let us understand from you, what have you understood?
Well, the trade licenses which are annexed, well, the drug licenses which are annexed in the petition, your lordship directed to inquire about this.
Why did we direct?
Genuinity of this.
Why did we direct?
Because,
because
since if it is not genuine, then the entire thing which was confiscated, that can be
why?
Because that is
why it can
contraband.
Be confiscated.
That is because that is contraband.
Why it is a drug is a contraband?
No, because the drugs and cosmetics license which was given the license to the present petitioner.
Yes.
Your lordship.
How does his license help him?
Whether it is genuine or not.
All right, genuine or not will come later on. Let us understand why the judge was calling upon you to find out whether licenses are genuine or not.
Because if it is ingenuine, then
if it is ingenuine, then what is ingenuous about it?
Then illegally he is holding.
Why?
If these licenses are not genuine.
So one of the licenses is genuine.
Yes,
now what is the impact?
Other two.
What does it mean? How does the other two and the license which is genuine are different from one another?
Further inquiry is required to be done. Because
does not a person, forget about being a lawyer, Mr. Pandit. A person who can read English and can comprehend English will not have these questions in his mind? Will they required to come from a judge?
No.
Then why is it that we are labored and we are bothered to find out? Let us, for argument's sake, accept one license is genuine. Will that prove legality of a transaction? Why no?
Because
you just said that it will be licit possession.
Well, the other
you just said that license is there, it is licit possession.
Not always. Your lordship is correct. It's not always.
Why not always? In which case it may not be, tell us.
Well, if it is not renewed in time, if it is
no, again you are going to the license. You're saying that the license is genuine. Now he is
one license is genuine.
One license. Now how the licenses are different?
That report is not there. They have
that report. So why does the state waste money on lawyers? Why? We understand that the state is cash strapped. Is it necessary to have someone just to have communication with third parties? We can directly interact with the police. They are after all salaried people. Why again another layer of persons and unnecessary wastage of money? Not necessary. Until and unless the layered person adds value to adjudication, we don't require lawyers. We can straight off directly interact with the investigating agency, get our information, formulate the reasons and pass orders. If you are just an errand boy communicating documents from agencies, again our queries, communicating them, what is the use of a lawyer? Not necessary. We can talk to the police. A police officer can be there and we will interact with them. The entire structure should be disbanded. There shouldn't be lawyers for the state, at least for criminal matters. What is the use? If a lawyer says one license is genuine, two licenses not genuine, I cannot.
Lawyer is not submitting. It is the drug
I
controller.
am submitting. The lawyer is saying from instruction, one license is genuine, two licenses not genuine. But I cannot tell you why two licenses are not genuine. How can one license be genuine and the other
I
are not
cannot travel
genuine?
beyond the report because the drug controller is a
Arey,
technical
if it is
person.
beyond the report, then what is the use of a lawyer? The lawyer should have intervened and said this report needs to be clarified. Tell us what is the impact of these two licenses not being genuine, one license being genuine. If the lawyer is not acting as a filter and adding value to the process of dialogue between the prosecutor and the investigator, then what is the use of the lawyer? The police is good enough. We get our data from police. We don't get our data from lawyer, as you're rightly saying. You can't say why they are genuine or not. It's the controller who has said. What should the lawyer have done? Either found it himself, what is the impact of license A being genuine, BC being not genuine, or that there is no real impact. If the lawyer cannot enlighten the court process, not necessary.
Well, kindly fix it. Well, I'll take information.
You should. And also take instruction about the transaction. That drug controller will not be able to tell you. If, let us say, he has a drug license and the place from where he claims the drug is there, that manufacturer says, no, we did not supply this match to the wholesale dealer. What does that mean? What does that mean? That means that this is a sham transaction where a wholesaler is in fact diverting medicine for non-medicinal use. That medicine having narcotics in it attracts not only the Drug and Cosmetics Act, but the NDPS Act. And that is where the assistance of the lawyer is required. If not, Mr. Panda.
Well, I'll take information right now.
One week. Further inquiry report is filed, further inquiry be made and report filed. Next.
Submit. Last order, my lord. Case was handed over. CID, my lord. CID is filed the status. There was a criminal antecedent, my lord. We have subsequently got this last page of the status.
Petitioner, we have considered materials on record. Petitioner is a member of a gang which induced individuals to part with money on false promise of part with money on by impersonating themselves as representatives of reputable mobile service providers. Petitioner has criminal antecedent. In view of the nature of the crime, having far-reaching consequences, we are of the opinion custodial interrogation is necessary and this is not a fit case to grant bail.
Would be capital.
Yes. Next.
Item number 9 and 10, my lord, they both emanate from the same FIR. It is a 2020 FIR, my lord, where allegations are that these petitioners took part in a CAA demonstration. Co-accused are on bail, my lord.
Means that petitioners have been falsely petitioners submit that a public demonstration took place against implementation of Citizenship Amendment Act. Petitioner has been falsely implicated. Co-accused are released on bail. He prays for similar anticipatory bail. He prays for similar relief. Learned lawyer for the state opposes the prayer. We have considered the materials on record. Allegations against the petitioner are general and omnibus. Co-accused have been enlarged on and have been granted anticipatory bail. Accordingly, we are inclined.
My lord, item number 9 has 9 petitioners in total. Great.
Next. Same. 9 হচ্ছে petitioners, 10 petitioner.
Yes, sir. Deeply honest.
Eleven. This is my application, my lord. And the licensed contractor under the WBCDCL of my lord district. Now, my lord,
Global trade is going to the sea.
Since electrical contractor under the Petition WBSTC. Now, my lord, the allegation is that, my lord, as per the, my lord, the version of the, my lord, concerned station manager, a person who is admittedly a offender under pilferage, make a statement to the pain of his nephew that two of the officials of that station manager accompanied with me went to disconnect the line, and there, my lord, I have taken a amount of rupees 40,000 in that. So I am concerned, my lord. I am neither the employer of that WBCCL not been, my lord, the entitled to entrusted with such a duty. My lord, I am the third person, my lord. And is, my lord, 183 BNS so the learned prosecution before the learned jurisdiction sessions court demonstrated, but in 183 BNSS and the recording, my lord, the victim, alleged victim, has stated that as per the version of the, my lord, SC, my lord, through his nephew, he has made this complaint. This is my submission, my lord. I am innocent.
Petitioner submits he is not an employee of the electric company. He, along with the officers of the electric company, petitioner, along with other officers of the electric company, had disconnected a pump, had disconnected the de facto complainant's pump, which was running on illegal, which was running on pilfered electric supply,
Direct hooking.
through pilfered electricity. He has been falsely implicated. He prays for Anticipatory. Learned lawyer for the state opposed the prayer. He contends one of the officers of the electric company, prayer for Anticipatory bail of one of the officers of the electric company, namely Sujon Rai, had been turned down.
And another one, my lord, that Debojyoti Sarkar.
Sujon Rai and Debojyoti Sarkar had been turned down. We have considered the materials on record. Petitioner is attached to Patiram Customer Care Center.
No, I am the electrical contract, licensed electrical contractor. I am not the.
He is the driver of the.
No. I am the licensed electrical contractor.
The petitioner is a licensed electrical contractor.
Not in the office.
So he was working at Patiram Customer Care Center.
Well, I am not working, my lord, there. My lord, I am the private contractor, licensed contractor. I am not
So
working.
your licensed contract activity was associated with that customer care center. He along with the officers of the customer care center had conducted a raid and seized the water pump used by the de facto complainant through hooking, full stop. Subsequently, petitioner demanded a bribe, a bribe of rupees 40,000 for return of the pump, full stop. In light of the aforesaid allegation, disclosing the primary role played by the petitioner in the offense, we are not inclined to grant answer.
suicide where the brother-in-law and his wife, husband was in custody and subsequently granted bail
How many years after marriage?
by 7 years.
Petitioners are the brother-in-law. Petitioner number 1 is the brother-in-law of the victim. Petitioner number 2 is the brother-in-law of the victim lady. Petitioner number 1 is his wife. Good stuff. It is victim committed suicide 7 years after marriage. Allegations of torture are general and omnibus. Custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined.
Deeply obliged.
Excuse me. Excuse me. Excuse me.
Lordship, I'm for the petitioner, Lordship. I'm praying for 1 week accommodation, Lordship.
Why
The
1 week?
advocate on record is seriously ill. That's why he's unable to.
Case diary.
Case diary, but today morning I have received, my lord.
We'll give you 1 day, not today.
2 days, oh, Lordship. Then.
Which was the case diary?
কি বলছিস?
Yes.
I'm praying apology, Lordship.
Why?
One day.
Let him take 1 week time, you arrest in the meantime. All right. Arrest him. Client.
I'm praying apology, Lordship.
Why should you apologize? Are we getting arrested? Neither me nor my brother's liberty is at stake, nor is your liberty at stake. The person whom you are
I'm praying apology,
representing,
Lordship. Unconditional apology.
I just pray to God that he sees your performance on the live stream. The responsibility that you have taken to protect his liberty and how you are discharging the responsibility. Next.
Renewed the prayer, my lord. The paragraph 10 I've stated change circumstances. Change circumstances, my
What is
paragraph
the
10.
change circumstance?
Paragraph 10.
Such a big order passed.
Yes, ma'am.
Then
Brother, I have changed circumstances, I paid for renewal the prayer, my lord. Paragraph 10 I've stated.
My lord, all the other cases, the applicant, anticipatory bail application was rejected.
কোনটাতে?
All other matters.
আমি
State matters, my lord.
after the order when this has been done.
what is the allegation against?
That he has misappropriated funds of the public money. And
Not
he was
correct.
the director of the company of Smart Charge. My lord, page number 11 of the petition, my lord, your lordship order is annexed to the second application.
That's true. That is there for renewal.
And my lord, there are similar cases against this petitioner. There are orders annexed.
Is case number কত?
What is the amount due here?
Like the complaint, annex the complaint.
40 lakhs, 50,000 was invested.
Well, so for my information, the payment already done by the 130 proceedings. Some payment has been done.
How much?
Well, that, my lord, the total amount has not been disclosed herein, my lord. Some payment already done.
Let us see what payments have you made.
In other words, I have to, they make the prayer for adjournment for the day.
I can.
We can easily reject it.
No, my lord, the
We are trying to help you.
that's true, my lord. At time,
If you are eager to show us that you have substantially liquidated the liability, we can give you some advantage.
that is true, my lord.
Nothing. No, in which case were you protected by the Supreme Court?
That is, my lord, the PS case number, my lord. I have split
What is the allegation in that?
the same things by the other persons.
6/2020.
Same things by the other persons. I have annexed the Supreme Court, my lord, the order.
Go to Supreme Court, Mr.
The PS case number 625, 526
Mr.
of
Maiti,
526.
submit that petitioner renews his prayer for anticipatory bail. He submits that he has cooperated during investigation and charge sheet has been filed. He also contends the proceedings. He also contends that de facto complainant has instituted proceedings for dishonor of check, and the present case was instituted to coerce him to make payments. In another case, the Honorable Apex Court has in special leave to appeal criminal 411/2025 has protected.
That is relating to PS case now 526 of 2020.
Protected his client from arrest. Learned lawyer for state opposed the prayer. She contends that petitioner is the promoter director of Messrs. Smart Choice, a firm which indulged in inviting a firm which indulged in fraudulent activities and induced innocent persons to deposit money. Thereafter, the monies were siphoned and misappropriated. We have considered the materials on record. Allegations in the first information report cannot be seen in isolation. Petitioner, along with petitioner, is the principal player, and as the promoter director of one Messrs. Smart Choice, induced innumerable persons to part with money on false promises of high return. Full stop. Thereafter, the money were diverted and misappropriated. Full stop. The extent, noticing the nature and extent of the organized, noticing the extent, the nature and ambit of the financial fraud impacting numerous persons, including the de facto complainant, this court was not inclined to grant pre-arrest bail to him. However, his wife was granted that relief. Stop. In these circumstances, submission of charge sheet against the petitioner merely crystallizes the accusation against him and does not justify revisiting the prayer for pre-arrest bail. Hence, application for pre-arrest bail is pre-arrest bail. The factual matrix of the case, seen in the backdrop of similar activities carried out by the petitioner, distinguishes the present case from the one where the Honorable Apex Court had protected his liberty. Stuff. In such view of the matter, we are not inclined to reconsider the prayer for pre-arrest bail. DJ.
May your lordship be pleased. Your lordship, the case is under section 420, 406, 120B and 34. The allegation is that the de facto complainant entered into an agreement for sale with one Jogmaya Banerjee. After that, the sale was done by virtue of a deed of conveyance. Thereafter, when they went for a mutation, they came to know that the plot of land has already been sold to one Shondha Dash. My lord, the petitioner before your lordship is the witness only. Your lordship may kindly peruse the FIR. I am the witness and I have complied with the 41A notice.
The petitioner is the grandson, my lord, of the prime accused, my lord. So, she was an octogenarian lady, my lord. She has expired, and petitioner is the main accused, my lord. Because the octogenarian lady, my lord, it is perceived, my lord, she was just there to put the signatures.
Jogomaya.
Jogomaya.
Jogomaya has expired.
Expired, your lordship.
You are not just the witness, you are grandson of Jogomaya.
My lord.
My lord, the main allegation is in the FIR. Allegation is against the Manoj Patnaik, who is the broker. Your lordship may kindly peruse the FIR. It can be seen that the Manoj Patnaik, after he was confronted, he handed over 2 promissory notes to the de facto complainant. And I have no knowledge about that promissory notes.
Petitioner contends that he is a signatory to the deed and was not aware of the prior transfer and was not aware of a prior sale deed executed over the self-same property. He has cooperated with the investigation and prays for answer. Learned lawyer for the state content petitioner is the grandson of the transferor Jogomaya Banerjee, an octogenarian lady who has since expired. He played principal role in the fraudulent transaction. He was aware that the land had already been transferred to one Shondha Dash. He played a principal role in the fraudulent transfer. We have considered the materials on record. One Shondha Dash had purchased a plot of land from late Jogomaya Banerjee. Subsequently, the said plot of late Corona Jogomaya Banerjee since deceased. Subsequently, Jogomaya transferred the land to the de facto complaint, self-same land to the de facto complaint for valuable consideration. Petitioner is Jogomaya's grandson and signed the deed as a witness. In these circumstances, his involvement in the fraudulent transfer is clearly evident. Full stop. But clearly evident. But the petitioner has cooperated with investigation and nothing is placed on record to show money trail reaching the account of the petitioner. Hence, we are of the opinion custodial interrogation is not necessary and petitioner may be granted and suitable subject to condition.
Grateful, your lordship.
Namida, Rashid হয়ে গেছে Next.
Well, I am for the petition. And allegation section 137 plus subclause 2 140 subclause 3 that is 363 364.
One of BNS and section 6 has been added.
The petitioner is the father of the principal accused. The son.
Services required.
Add section 65 BNS and 6 of POCSO Act to the liberties given.
and 85 of BNS, my lord. 2 years,
When 2
my
years
lord, my lord, may I place, my lord? This is
Who are you?
I'm husband, my lord. 2 years back, my lord, there was a love and affair of the petitioner and the victim that was not supported by the family members, my lord. So they fled away, my lord, and they got married. So, my lord, thereafter, my lord, they started living at the matrimonial house, my lord. In the meantime, my lord, the parents of the girl, my lord, tried all their means to make them separate, my lord. So, my lord, once 1 month before the incident, my lord, they came to my house and they said that they have accepted their relation and their marriage, so they want to take their daughter to their house for some days, my lord. So I agreed, my lord, and they take the deceased, my lord, to their house. Thereafter, my lord, on 10th August 2024, my lord, I went to the house of the parental house of the victim to bring her back. The girl, family members of the girl, my lord, they denied. They said that they do not want to send their daughter back, and in front of me, my lord, they threatened their daughter that if you go with the petitioner, then we will kill you. Thereafter, I have been thrown out from their house, my lord. And
Did you lodge a general diary
my
saying
lord,
this?
in this, my lord, I did not take that so seriously, my lord. Thereafter, she committed suicide, or whether she has been killed, my lord, I do not know, my lord. But my lord, thereafter, my lord, I lodged complaint, my lord, page 31.
I have acknowledged your statement.
Thereafter, my lord, I lodged
Your
complaint.
wife was taken away, forcibly detained, threatened, as you say. Then a normal conduct would be inform the police.
My lord,
let us see what is there.
My lord, kindly see the judicial statement of the de facto complainant. My lord, there are some witnesses who said that just before the incident, the husband went to the house, went to her paternal house, my lord. My lord, next page also, my lord. My lord, kindly see page number 8 to 10.
Very vague statement. What we have seen is a very vague statement. Petitioner submits there was a romantic association between the petitioner and the victim lady. Her parents were unwilling. They agreed to marry, but the parents of the victim was unwilling. Accordingly, as a result, the couple eloped, full stop, and was staying as husband and wife. At this juncture, the de facto the parents of the victim, relations of the victim intervened and took her back to their residence. On petitioner tried to persuade them to return to permit the victim to stay with him. They abused and threw the petitioner out. Thereafter, victim committed suicide. He has been falsely implicated. He prays for anticipatory bail. Learned lawyer for the state opposed the prayer. He contends witnesses saw immediately prior to the incident, petitioner and other accused were running away from the spot. We have considered the materials on record. Victim lady committed suicide at her parental home. Petitioner contends the couple, petitioner contends he and the victim were residing together. He and the petitioner contends they had fallen in love and had married against the will of her parents. They were residing as husband and wife, and the victim victim lady was brought back, was compelled to return to her parental home against her will. Full stop. Statements of witness, she committed suicide at the parental home. Statements of witnesses showing that petitioner and others were seen running away from the house appears to be unnatural. Now, home appears to be unnatural. Possibility of implicating the petitioner owing to their resistance to the marriage between the couple cannot be ruled out. Under such circumstances, we are inclined to grant answer.
Grateful, my lords.
Next.
20.
My lord, I'm for the
My lord, there is a case account with family man. Lordship, they are both family men and both they are family man case or counter case, my lord.
Head injury is there, Lordship. Firstly, his victim was taken to Manikchok Sador, then he referred to Malda District Hospital, and CT scan report is not there, Lordship.
Huh?
CT scan report is not there.
Was where they did they undergo CT scan?
Lordship is referred at the Malda General Hospital.
Just get
And
the
yes,
report.
Lordship.
Adjourned Monday.
Monday.
Get
Medical report from Malda General Hospital be produced. Next.
22. Petitioner, my lord, the case is under section. Petitioner number 1 is husband, 2 and 3 are parents-in-law, 4 is brother-in-law. After 12 years of marriage, my lord, the wife committed suicide and died. My lord, kindly consider the last annexure, annexure P3. My lord, the petitioner victim's father demanded rupees 6 lakhs from the
petitioner's
father demanded rupees 6 lakhs from the my lord petitioner number 1. And my lord, he refused. Thereafter, a Salishi meeting was my lord held, and it was decided, and the decision was taken down on a stamp paper that if within 16th January, rupees 6 lakh is not paid to the victim's father, my lord, criminal case will be initiated. My lord, he was forced to sign. My lord, the petitioner number one was forced to sign on that stamp paper. Thereafter, my lord, he did not pay that amount. On 17th, my lord, this case was started, and 15/12, before 1 month, the wife died.
Petitioners submit that petitioner number 1 is the husband of the victim lady. Petitioner number 2 and 3 are her parents-in-law. Victim had 4 is what?
Brother-in-law.
Tell us, petitioner number 2 are her parents-in-law and is her brother-in-law. They contend that victim committed suicide 12 years after marriage. Stop. No FIR, initially no case was registered. De facto complainant demanded money, which they were unable to pay. As a result, they have been falsely implicated in the case. They pray for ancestry. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Incident occurred 12 years after marriage. Full stop. Allegations of torture are general and omnibus. Full stop. It is the FIR. If FIR was not immediately lodged, it is contended. De facto complainant demanded money, and as the petitioners failed to pay, they have been falsely implicated. In view of these facts, we are of the opinion petitioners may be granted and sued.
Charge sheet not submitted.
I'm good.
For the petition, my lord, the FIR lodged against the unknown miscreant docuity case, my lord. My lord, some articles recovered from the 3 persons, Obhijit Mujumdar and my lord, the Faruq Sarkar and my lord, the Subroto Khan. And petitioner is concerned, no recovery from the house of the petitioner.
Robbery with murder.
Then we have considered the
And my lord,
materials on
proclamation has
record.
also been issued.
Petitioner and accused had committed robbery
My lord.
at the house of the deceased. At the house of the victim, he was also murdered. In view of the gravity of the offense and as petitioner had absconded, we are not inclined to grant that.
My lord, grateful, my lord.
Next.
Let's say I for the petition. Let's say charges submitted, no recovery, fake currency.
Lordship, petitioner is the son of the accused who was arrested, and they were associated with this fake currency note for several times.
We have considered
And there are
materials
serious
of
allegations.
record. Petitioner is the son of the principal accused.
Principal accused, and all of them are connected. He was arrested.
Petitioner is son of one of the accused who had been arrested with fake Indian currency
There are
notes.
serious
Materials
connections,
on
Lord.
record show petitioner is a conspirator in the crime. Under such circumstances, we are not inclined to grant answer. Next.
Twenty-five.
My lord, I am appealing for the petitioner. My lord, the present petitioner is a higher secondary examinee. His examination is going on. My lord, on 20th, while playing, the victim got injured. He fell on the ground. My lord, he lost his teeth. Now, my lord,
falling on the.
now after 4 days, the complaint was filed. Under section 307.
Higher secondary exam.
My lord, I have annexed the document.
Secondary exam.
My lord, I have annexed the documents, my lord.
He had to undergo maxillofacial surgery also.
We have considered them.
My lord, kindly see these statements, my lord. My lord,
seen it.
My lord, kindly see, my lord, whether my lord, it was playing, my lord. They were playing.
3 statements are there of those boys to whom this boy was playing. Now, my lord, they stated that intention to assault was not there. My lord, kindly see.
What was the intention?
My lord, they were playing.
Playing to uproot teeth.
No, my lord.
My lord, he fell on ground, my lord.
Huh?
Since this boy is aged about more than 18,
well, they
didn't allow him initially, but in spite of that, they were playing. But
Child is 8. Young boys are playing. You come there, you have to be inducted in their game.
My lord, kindly see.
But I have folded the pages.
What did he use? Only blows.
My lord, wooden stick.
My lord, he,
Wanted to hit in the head and then
my lord,
and five the
What is
mouth
this?
is the face is
My lord, folded pages.
defective. Day was in hospital.
You were playing with Lati. Is your age?
18, my lord. My lord, he is giving a higher secondary examination this year.
After examination, go to
We have zero in sympathy for him. Someone who hits a child like this.
My lord, may I pray for them one? My lord, the higher secondary examination is ending on 17th. My lord, keeps it on the 20th. My lord, he'll surrender by that time.
Take the higher secondary exam. Adjourn 2 weeks. Petitioner shall not be arrested in the new. Then don't press and sir. Yes.
Lord, I appear for the petitioner, my lord.
My lord,
The
I'm the de
allegation,
facto complaint.
allegation is under section 406, 420 and 120B, my lord. My lord, the allegation is that the petitioner has taken, my lord, a loan of rupees 20 lakhs, my lord, and thereafter, my lord, the payment to the extent of interest were paid, my lord. And thereafter, the remaining part was not paid, and that is on the basis of that, my lord, the FIU was lost. In fact, my lord, and sum of rupees 12 lakh, 12,238 has already been paid, my lord. I have, my lord, annexed, my lord, the
He has paid 5 lakhs, and regarding the 12 lakhs, my lord, that is including the interest part, my lord. And he has not complied with the 41 in notice.
What?
Thrice it has been served, my lord.
What noted he will do? Complying with your 41(8).
But my lord, the principal amount 5 lakhs that was paid in 2019, my lord. Thereafter, we had tried to communicate with the accused persons, my lord. However, my lord, after paying that 5 lakhs, that is the principal amount for from 2019 till now, my lord, they have not given us any amount, and thereafter when
For recovery.
my lord, we shall, my lord. But however, my lord, when we have initiated this case, my lord, they had called us and wanted to settle the matter. However, we get to know that they have filed an anticipatory bail application before your lordship.
Petitioner submits that he had taken a loan of rupees 20 lakhs. He has made in, when did you take a loan?
my lord, it's 27.
2017.
17.
In 2017, he has made he paid interest on the loan. Part payment of the principal sum has also been made. He pays for anticipatory bill, and a lawyer for state opposed the prayer. She contends petitioner has not cooperated with investigation, and a lawyer for de facto complainant submit. Since 2019, petitioner did not make further payments. We have considered the materials on record. The case has arisen out of a loan transaction between the parties in 2017. Petitioner has paid interest on the loan. A portion of the principal has also been paid. It is undertaking admitted some admissions are there. Admission 3 years. we are of the opinion whether there was initial deception at the inception of the, whether there was deception at the inception of the transaction has to be assessed at the appropriate stage of the proceeding. However, process of criminal law cannot be unleashed to recover outstanding dues. Under such circumstances, we are inclined to grant anticipatory bail subject to condition meet investigating officer once in
Great.
Deeply objected. Deeply.
Yes, Mr. Fannal.
May I
27.
Well, on the last occasion, your lordship asked me to file my affidavit in opposition in the meantime. May I file that? Copy দেওয়া হয়েছে? The copy service হয়েছে।
হ্যাঁ
ব্যাংক কোথায়?
ব্যাংক জানি না ব্যাংক
আপনার কে ছিল ব্যাংকে? আপনার তো ব্যাংকে
তো ঠিক আছে না এই অর্ডারটা তো করছি
Yes.
No, before taking your losses, I give your losses the 3 dates of particulars so that your losses can understand.
You filed the opposition. Yes.
No,
You got the opposition.
Yes, I got the opposition. Well, that's reiterate what they have said before. Now your losses will find the property in question which was confiscated by this impugned order. This was purchased, my lord, in 1999-2000. This is one date, your losses. My lord, proceeds of crime for which the persons, my lord, the erstwhile directors who have now declared to be fugitive offenders, 2008 to 2011. And share transfer, my lord, took place in the sometimes in 2012. My lord, by way of share transfer, my lord, the entire shares have been taken over by the present directors. Now, my lord, if your losses go through the impugned order, it starts at page 74 and the relevant page findings at 75. My lord, according to me, my lord, this is no, my lord, basis and it doesn't have any chain of findings, my lord, the coming to the reasons. If your losses kindly consider page 75, para 9. From the documents annexed with the written notes of submissions of the interested person, these court of the view that the interested persons has failed to satisfy this court has acquired a legitimate interest to bona fide transfer of share. Your losses will kindly consider records of RSC at page 151. That was recorded in the RSC's records. These court, how could they question the documents or the actions of the record, the ROC? This is not the proper forum. Then your losses, on the other hand, kindly see your losses, probably these should be the reasons.
appear from the application of the prosecution under section 4, it has been provided the list of immovable properties under Annexure C, which the property mentioned in serial number 4 of the table is the property for which the rival claim has been raised by the interested persons. The ED has already obtained a provisional attachment order in respect of those properties, wide order dated 30th March 2021 in connection with ECR such and such. It further affairs fugitive economic offenders Pushpesh Kumar Bed and Dharmesh Bed were the directors of Ruddoshi Textile Private Limited, and the property by deed number 1999 was purchased an amount and it was mortgaged in SBI as per the valuation reports of the value of the property. Well, the straightway losses goes to the property. Properties of 1999. It must relate to the proceeds of crime. Even under the Fugitive Offenders Act, then the property was given on rent to one Sanjay Mishra, who was neither paid any rent nor paid the cost of the property, as disclosed by Dharmesh Bed. It has been vehemently contended by the Pushpesh Bed left India in 2012 and has not been in contact with any. Subsequently, it was learned through mail from AGM that the property was mortgaged against the loan. That's mortgaged amount the present the company has been secured, want to secure, and that's the High Court order. And the SBI came up before the Honorable Court and said they will release the deed. And then your losses kindly see. So given the fact, I am of the view that the property that the petitioner has put up a claim having an interest does not seem to be a legitimate interest. Not on what basis I am putting a question to myself. This is a share transfer. In acquired bona fide without knowledge, the property was the proceeds of crime. Now your losses. Where is the finding that these are proceeds of crime? Just because someone taken it. The offense relating to the erstwhile directors 2008 and 11, I believe that will not be disputed. And the property purchased at least 10 years before, which was mortgaged in favor of someone. So this has been now confiscated. We have not been anyway involved in the offense. It proceeds that these are proceeds of.
You are not involved, you are the setup man.
That's your losses. Where I do not find your losses.
We are finding it, Mr. Sharnam.
This,
you are a sham person to whom purported shares are transferred to create the screen. Show us what was the money received by Pushpendra Boyd and Dharmesh Boyd when they ran away and the company was defunct and you brought the shares.
That was not the fact. This was against the dues of the erstwhile companies in respect of the employees. That was paid. So that was paid.
Who transferred the shares to you?
All the three.
Who are the three?
These three, Prem Prakash, Pushpen and Dharmesh. All the three.
93% share
and all Pushpen and Pushpesh, they were holding 97% interest of the shares.
At that time, they had already run away from the country.
No, before that, shares were transferred. Shares were transferred, I give you also the date. 13th January 2012.
2012 and Pushpendra left the country in 2012.
After that, your losses. And this cannot be the proceeds of the crime, my lord. Because the property purchased, my lord, 1999.
Where is the offender's fugitive?
I give you a loss. That. Now your losses will find definition of proceeds of crime. Section 2 small k means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Or the value of any such property. Yes, the value of any such property, or where such property is taken or held outside the country. The value of any such property is not the proceeds of the crime. It cannot be.
It is the equivalent of the proceeds of the crime.
I couldn't form equivalent.
of the proceeds of crime.
Value of such.
Please go through Bijoy Mohanlal Choudhury. Madan Lal Choudhury. Sorry.
Well, then kindly.
Proceeds of crime is, let us say, 20 crores by someone who enters into money circulation business and had invited money from people, 20 crores. Nothing is found, but a land is standing in his name, which was acquired earlier, is 15 crores. They have a right to attach it.
But then your losses, give me a day's time so that I can go through the judgment and come back.
Lifetime's time.
This is the only point now.
We don't know what is the only point.
I do not find from the judgment under in question before lawsuits.
Huh?
The judgment and the judgment I am selling, that's not the finding.
Doesn't require. It just says it's a proceeds of crime. So you have to demonstrate before us in relation to the law. And since you place the law, we indicated where it can become the proceeds of crime. Given authority contrary, we understand. Otherwise, plain reading says anything which is collected or corrected with the scheduled offense activity or the value of such property that is the connected with scheduled fraud are proceeds of crime. It's a very harsh law, but that is exactly what the lawmaker has made.
Well, then kindly give me a time. I will come back and join an issue. But how could it be the value of such?
You want, we have no difficulty. Take your time. We have a lifetime. You also have your life.
In the meantime, I take the opportunity also. They have used opposition. I have not given reply to that. I will do that here.
Not required.
Affidavit in opposition file, reply 2 weeks. Matter will appear 6 weeks hence.
I don't that much of time. Next week, your losses. Next Wednesday, I will.
So, Sharnal, you can pray. You have prayed next week. We have given you 6 weeks. Next.
6 weeks is the problem. Before what? 6 weeks. Or may I renew your losses? Well, at least
4 weeks. 4 weeks.
4 weeks. Well, since
2 weeks, 4 weeks. Within 2 weeks, file your reply. 4 weeks.
Well, since there was an order, in terms of the law that administrator to take possession of the property, should we go ahead with that?
Not necessary. Your property is attached already.
Property was attached, and thereafter that attachment order was set aside by the Honorable Single Judge in a case under PMLA. There against an appeal before the Honorable Division Bench was pending, and this confiscation is under Fugitive Offenders Act.
So that confiscation order is there.
And order is there for the administrator to take possession. So we should go ahead.
So we have to see, Mr. Why the provisional? Mr. Sannal, you have a better argument to show us the order of the single judge as to why the single judge has set aside the provisional attachment. Was it in relation to a procedural lapse, or His Lordship has agreed to the proposition that it is not proceeds of crime? Let us examine that.
All right.
Deeply obliged.
28.
28, I am
Next matter.
But I'm appearing for the petitioner, my lord. We have assailed a judgment dated 16th August 2024, my lord. Both the accused persons therein were acquitted. My lord, my main submission is with regard to the judgments. We have referred to certain judgments that will be reflecting from the case diary. Those judgments were never considered at the time of passing the impugned order.
Case diary.
In the PCR.
PC.
PCR.
So how do you prefer? Did you take leave to appeal?
My lord, I am for the state, my lord. As
The state has to take leave to appeal.
this is a GA application, my lord.
How does the state file an appeal? Under what provision of law?
3.
3.
$378, my lord.
What does subsection 3 of 378 say?
Specially.
Not written on our face, it's written in the book. Read out loudly. See subsection 1, 2, and subsection 3.
Yes, yeah.
Huh? What does it say?
I'm trying to open it, my lord. Trying to open it in the tab.
Trying to?
Open this CRPC.
No. And your appeal now will be under the new law.
The state government may, in any case, direct the public prosecutor to present an appeal to the High Court from an original or appellate order of an acquittal passed by any court other than a High Court, not being an order under Clause A or an order of acquittal passed by the Court of the Session in revision.
Then,
if such an order of acquittal is passed, in any case in which the offence has
now
been
come to subsection 3. What does it say?
no appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court.
So, where is the leave?
I should have read.
You filed this petition of appeal? Huh? You are in the state panel. How many years you are practicing?
6 months, man.
6 months. How can you be in
No,
the
6 months in the state panel.
your entire career as a lawyer?
3 years.
3 years. Where is the public prosecutor? A leave has to be filed. You're adjourning this matter. In the meantime, take out an application for leave. Then your memo of appeal. This is the first time you are filing an appeal. So you couldn't ask anyone how an appeal is filed. You didn't read the law. You are one of the lucky few who get opportunity to appear for the state. Don't you feel that you should prepare yourself accordingly? It's very easy to get benefits, but it's very difficult to justify yourself. Where is the public prosecutor? Where is the public prosecutor? Passed over. Next.
Uh, 30.
I've been appointed by the High Court Legal Service Authority.
Please ask the public prosecutor to come.
I've been appointed by the High Court Legal Service Authority. For the appellant, my lord, there is a Section 5 application. My lord, there is a 10 years, 321 days delay. My lord, petitioner approached the District Legal Service Authority, South 20 Protocols after almost 9 years, my lord. And this is the letter, my lord.
We'll call for the LCM. Adjourn for this. We'll dispose of this matter here. Next. तो बोला है वहाँ पंडित बोला है प्रताप के बाद जामीन
Three 302 life, 27 Arms Act life.
Same order. Admitted. Issue usual notice call for trial court records. Next. Tip.
Admitted.
Date to be tagged with CRA 60 of 2025. List along with ones. এটা এলো না কেন CR এর সঙ্গে made an
34.
34, my lord, special leave to appeal against tell my lord, I'm not pressing this application. Liberty
told
to take
you.
back the judgment.
not pressed.
My lord, liberty.
Certified copy be returned after replacing the same with a photocopy. Application he is at liberty to take appropriate steps.
Deep level.
Next.
35.
If I may appear for the respondent, it's a special leave to appeal filed by the state against an order of acquittal.
Nobody is there.
There is a delay of 42 days.
Sochit Talukdar. Where is Sachit? Not this week. Please inform Sachit.
Wait.
All the Passover matter.
Sure.
Item 29. Yes, Mr. Public Prosecutor. See how the appeal is filed against order of acquittal. Go to the prayer. No leave sought.
Madam, I do not know who has given him the permission to file it.
I do.
It did not travel through me.
We asked him. This is the first time he is filing. He doesn't know. He doesn't know which
Now, there is a
provision.
circuitous method now adopted by the concerned departments. They want to prefer an appeal
No, but
because
then this goes.
all the recommendations which had been sent to me were refused by me.
But unfortunately, this appeal under subsection 2 has to be by the public prosecutor.
I have pointed
That's
out
what
to
we
I have
showed
pointed
to
out to
your,
the learned legal remembrancer, but he is still going on appointing individuals for preferring appeal on behalf of the state, and they are filing it.
How
He
can
cannot
he?
prefer an appeal. Who is he?
How can he?
He
has-
is doing it.
See, we may be.
But I have written him. I have shown him the provision.
It's the public prosecutor or the district magistrate.
His opinion is whichever opinion he is sending for me. My opinion, I am refusing it
Oh,
because I have said these are frivolous applications.
it will be direct the public prosecutor.
Yes.
It cannot be to a person in the panel. How can it be straight off sent to an officer of the panel? Because we are surprised, Mr.
Frivolous
Public
application.
Prosecutor, that while you are whether frivolous or not, we have not seen. But we were surprised that with Mr. Devashish Rai holding the office of Public Prosecutor, his appeal on behalf of the state of West Bengal is without a leave to appeal. And the lawyer representing the state is gloriously ignorant that he requires a leave. They are young boys. I don't want to dampen anyone's spirit, but at least if God gives you an opportunity,
No, they are,
you should live up to that
This
opportunity.
chamber is totally overburdened.
He's from whose chamber?
My junior's chamber, Mr. Ovik Ghatak's chamber.
Ovik's chamber.
Too much overburdened.
He doesn't know how to file a leave to appeal.
I am ashamed of myself for not being in the public prosecutor.
It's very. No, because we have seen that from Mr. Ghatak's chamber, there are good lawyers. Mr. Poti is there. He is quite good. Huh? That girl is also. They are good. The question is not, this is something which is very basic. We learned it almost, I think, the first month in our profession, how to present an appeal. You are appearing in an appellate court and you don't know how to institute an appeal. We have adjourned it for 2 weeks. Please take remedial measures. We wanted to indicate to this. We don't want to be harsh with members of the bar. And he is a young boy. What will we say? We made him read the law. Please file the leave to appeal and take it up. Say that the judges have expressed surprise that how are you directly appointing members from the panel? You have to instruct the public prosecutor. The law is very clear. The government or the district magistrate, these are the two entities. They instruct the public prosecutor and none else. The law is very clear.
Yes.
That is why your appeal in the other case was not entertained.
Yes.
It can't be that it's clear who has the authority to file the appeal. And apart from that, it's only the victim.
Yes. The victim.
Victim is an independent power. Otherwise, though, the appeal has to be under 378, the for procedures laid down there. And it is very important, because you have to see 419 in light of the power to withdraw a case. Who has the power to withdraw the case? Under 321 CRPC? Is the public prosecutor. And therefore, the carriage of proceeding is of the public prosecutor and none else. And here we understand at least the lawyer may be an additional public prosecutor. You may say that it's
No,
here
but
is-
it has to be managed. We have seen it. It was.
I've
used to
never
be-
seen, ever seen.
Babu or Justice Nur Alam Chowdhury
Always the signatures
signed
you
by
will
the
find.
public prosecutor.
All things have diluted. I think till 2005, never an appeal from the state was filed without the signature of the
Now the public prosecutor. It has to be by the public.
or at best by the additional public prosecutor. Ask Mr. Moitro, Mr.
Lordship,
A. Goswami.
That time, Mr.
Always,
Moitro,
always.
there was a total distinction.
Yes,
of the district.
yes, of the district, and he used to file it for
In
those
respect of
districts
his
and other districts, this person. Without that, you can't. It is not maintainable.
Not maintainable. As such, this appeal is not maintainable in its form.
Only that we can condone that it's a, what is his authority?
He doesn't have any authority to file. Only the learned legal remembrancer can enlighten your lordship's manner of the same person.
While here, at the time of admission of the appeal, we noted that the petition of appeal was not accompanied by a prayer, by an application seeking leave to appeal under subsection under 419(3) BNSS. Given this situation, we called the learned public prosecutor. Learned public prosecutor opined that he had not received instructions to file appeal. The appeal had been preferred by an empaneled lawyer upon the instruction of the legal remembrancer. Subsection 2, section 419, subsection 491, subsection 1 and 2 read as follows, full stop. A plain reading of the aforesaid provision show appeal on behalf show that the district magistrate subsection 2 koro show that the state government show that the state government must direct the public prosecutor to present an appeal against acquittal. It prima facie acquittal. Legal remembrancer shall submit report clarifying the position, how the appeal was not, how the appeal in the present case, how the appeal against acquittal was filed without giving instructions to the public prosecutor to present the appeal. Full stop. Report shall be filed on the adjourned date. Matter will appear 1 week hence. A copy of the order be sent to the legal remembrancer, Government of West Bengal, for due compliance. Any appeal should be through the public prosecutor. If that is not so, let them appoint him as a special public prosecutor and file it. Good job.
36, my lord, I am appealing for the petition.
Yes.
My lord, in earlier occasion, your lordship directed my learned friend to take instruction any threat perception.
Threat perception.
Lordship, as per report, the victim is directly
All right,
not
report is
threatened.
placed on record. A report shows the petitioner had entered the jurisdiction.
And-
He had not threatened the victim.
But two of his friend has been threatened by the accused.
Oh,
The victim has written letter, Lordship. There is
give a
it is-
report. Let her respond to it.
Lordship.
Your bail should be cancelled.
My lord, the petitioner now residing, my lord, elsewhere.
Wherever residing within territory of India. Report is placed on record. Copy of the report be handed over to learned lawyer for the petitioner. Objection, if any, be filed. Adjourn 2 weeks. Don't press the application. Next.
Grateful, Lordship.
Yeah,
Grateful.
1919.
37.
Well, the only condition is that not to enter into the jurisdiction, my lord. Order was passed on 4/11/2020.
Compliance report is there.
What?
Compliance report is there.
What is the compliance report?
And your lordship's order was carried out.
Was it carried out?
He will say. This is not.
Was it carried out?
I submitted the report.
Have you read the report?
Yes.
What does it say? Was it carried out?
Submit to condition.
Was it carried out? Nobody reads.
Subject to conditions complied, that is said.
No. What are the
Where is it saying?
but his movement request to be restricted?
Satisfaction that their movement request to that is our order.
Is that your
We know our order, sir. Was it carried out?
Then condition.
Then and also subject to condition
Inquired of the
maintained,
condition of honorable
and
High
they
Court.
shall also appear before in time. So and so surrendered and appeared. Then thereafter, where is the compliance of the fact that they shall not enter the jurisdiction?
That is not.
Yes, a subject to condition is maintained.
Report is placed on record. Petitioner has complied with the condition of bail
On 4/11/2020.
full stop. And condition of bail, that is they shall not enter, petitioner, that they shall not enter the jurisdictional police station, full stop. Under such circumstances, we waive the said condition of bail, the said condition, other conditions of control. Next.
Report is kept with the record. They are writing in this way, what?
Yes, Ms.
My-
Holmes.
302 life, 10,000.
38.
Appellants are in custody for 7 years, 4 months now, but life is there.
Who is
And
first?
it is
38 one there is no endorsement for the state matter. Service project. 39 I mean 38.
7 year, 4 months in custody. Due to land dispute, appellants were making a thatched roof and they were stopped and a quarrel took place. They are co-sharer in the same property, Lordship, all cousin brothers. And victim died 7 days after the incident occurred on 10th of October 2017. And he was first taken to Khorgram Primary Health Center. From there, he was referred to Kandi SD Hospital. From there, he was referred to Murshidabad Hospital. From there, he was referred to NRS Hospital and he breathed his last at NRS Hospital after 7 days after the alleged incidents. No dying declaration. And Lordship, my humble submission, it is a case of 300 and there was no intention to kill.
Are the eyewitnesses?
Lordship, his wife.
PW
Lordship, this is
3. PW 3.
PW. No, Anwar Bibi.
Anwara. That is 2.
বউটা কোথায় গেল? না না PW2 is sister. This is the certified copy of the evidence, madam. Anwar a bone.
2, 3 both.
Ilufa Bibi is wife,
Ah.
PW3. This is the certified copy of the evidence.
There was a land dispute. Salish was going on. The inspector came on that day. They beat them up. You suffered injury. There was a counter case.
No, there was no counter.
Then the Anwara left the hospital.
These petitioners they suffered some minor injuries. They were at hospital. They were arrested from hospital.
Oh,
These appellants.
they also suffered injuries.
Yes, but not so serious. They
Over the
survived.
same incident?
Yes, so same
Did
incident.
they lodge a counter case? Because
No, they didn't lodge. They were arrested from
Huh?
hospital. They didn't lodge any case.
No, come to page 19. Fajle Haq, father of Safir.
That was
the-
a previous case.
Oh, that was a previous.
Yes, their land dispute was going on. There was 144 injunction.
Hmm.
There was Shalish. Then the revenue officer came.
Hmm.
And no, they didn't bring any weapon. They were making a house.
Appellants contend they were in custody. They are in custody for 7 years.
4 months.
For more than only one appellant is there.
Two.
Contend that they are in custody for over 7 years. Incident occurred in the incident occurred. There was a land dispute amongst parties. Incident occurred in the house of Asadul while Salish was going on. Asadul died 7 days after the incident. Appellants did not have intention to commit murder. They pray for suspension of sentence. We have you are appearing.
My lord, let a copy be given to because this is of 2019, my lord.
Tomorrow.
2019 তো?
Tomorrow we are keeping.
My lord, okay.
Next.
Obliged, Lordship.
I'm for the applicant. My lord, 302, my lord. Conviction for life, my lord. Paper book is not ready today, my lord.
No.
Till now, my lord. 9 years, 1 month is in custody. My lord, PW1 and PW2 is supposed to be the eyewitness in this matter, my lord.
We have considered the evidence on record. PW1 and 2 are eyewitnesses. They state appellant had come to the locality and hurled abuses in the evening. Thereafter, in the evening towards his mother, that is the deceased. Thereafter, he came back and chopped her with a sharp cutting weapon, that is bonti, on the shoulder and face and other parts of the body. PM doctor, PW. Who is the PM doctor?
PW11, man.
PW11. PW11.
Lordships.
Found number of injuries on the body of the deceased caused by a heavy sharp weapon and opined death was due to the injuries. Ocular version of eyewitnesses is corroborated by medical evidence. Hence, we are not inclined to. Sentence is one of life imprisonment. Hence, we are not inclined to suspend the sentence.
Grateful, Lordship.
Next.
My lord, 40 and 41. 41. My lord, one of the appellants was granted bail by this honorable court. My lord, the order is annexed at page 55, P3.
Public prosecutor.
What? Yes, my lord, what the public prosecutor has done. My lord, day after day, your lordship is hearing this. That order of bail was challenged in the Supreme Court. And the Supreme Court, after hearing in detail, upheld this honorable High Court's order. And this was way back on December 20th, 2024. Now, the IO is coming to court every day. The public prosecutor, yes, we did not have any clue because we were not served with a notice. Same. co-accused, that bail, my lord.
Not under 52A, but on the ground of
No,
detention.
even their lordships, my lord said, with paragraph 2, the having regard as to the observation made in the by the
paragraph 3, please read out.
the observations made by the High Court regarding 52F are only for the purpose of considering the prayer for respondent for suspension of a sentence and shall not affect the case on merits. And the bail was granted under 52A so far as the co-accused was concerned by this honorable court. And they were fully aware.
Appellant contents co-convict Joydev Das has been granted bail.
Gauri Das.
Gauri Das was granted bail. He prays for bail on parity. Learned lawyer for state opposed the prayer. We have considered the materials on record. Appellate stands on the same footing with Gauri Das. The latter has been.
My lord, kindly fix it tomorrow, my lord. I'll make sure the learned public prosecutor.
The latter has been granted bail by a coordinate bench of this court, which was upheld by the Honorable Apex Court. Under such circumstances, we are inclined to enlarge the appellant on bail on parity. It is clarified that the order shall not be treated on parity. The order issue with regard to non-compliance of section 52, it is clarified impact of non-compliance of section 52 capital A of NDPS Act shall be assessed independently during hearing of the
Extremely obliged, my lord. To the satisfaction of the learned trial.
Next.
39 টা আমি দিতে পারি না।
42.
Lord, I am for the appellate. Lord, the appellant has been convicted under section 302 of the Indian Penal Code. Lord, the case was registered under section 308, 341 of the Indian Penal Code. Subsequently, Lord, the police had completed investigation, submitted charge sheet under section 304 of the Indian Penal Code. However, Lord, the learned trial judge had been framed charge under section 341, 302. Ultimately, the conviction was given under section 302. The prosecution case is that the two boys, they are aged about 16 and 13 years were playing. These persons, the appellant had came and assaulted by a piece of wooden bottom which was fallen on the place of occurrence. This is that he sustained injuries. He was taken to the Betwadari hospital. Thereafter, he was taken to the Noida district hospital. And subsequently at NRS hospital, the boys had died. During the course of trial, I was all along on bail.
How long you were in custody?
Conviction, after conviction, I am in custody, about a year.
দাদা আমাকে তো ডেপোজিশনের কপি নেই deposition copy is not attached.
Who are the eyewitnesses?
Below the eyewitnesses below the PW 8 and 9. Below though they were not, below they were examined.
Kind enough to show us the page where they have, where their deposition is discussed, 8 and 9.
What is the name of the petition?
Below that page, running page below 72.
Originated.
119 paragraph, page 73.
73.
Category to be attributed in charge sheet. From where this has come, this sort of, I don't know.
এটা এইভাবে কিভাবে প্রিন্ট হয়েছে?
It is not paginated also.
From where is it?
Pagination বলছে।
দাদা তুমি নিচের পেজটা পড়ো, নিচের ওইটার সাথে মিলবে না, আমাদের পেজিনেশন নেই, নিচের দেখো।
And medical evidence?
Medical Miller PW 5, 6 and 7 and 10.
Hey, PM doctor.
PM
PW7.
PW 6, the person who treated the victim first. Thereafter Miller PW 7.
Sir,
My lord.
you understand the manner in which the judgment is written is like finding a needle in a haystack.
নেই আমাদের। Page 115 of the
Appellant contends he was on bail during trial and did not misuse his liberty. He had no intention to commit the murder. He prays for suspension of sentence. Learned additional public prosecutor opposes the prayer. We have considered the evidence on record. PW 7 and 8 and 9 are eyewitnesses. They stated appellant had hit the victim with a wooden bottom on the head. Full stop. PW 7 is the PM doctor. 8 is PW 7, PM doctor PW 7 noted injuries on the head of the deceased, and however, he did not state that the injuries were sufficient in ordinary course of nature to cause death. In appellant caused death, whether the appellant intended to commit the murder requires to be assessed during hearing of the appeal. Yeah, under such circumstances, we are inclined to suspend the sentence.
But one of the autopsy surgeon says that the cause of victim's injury and death was entirely homicidal.
Homicidal, whether they were sufficient to cause death, he is not safe. Next.
43, 44, 45.
These matters, my lord,
My lord, 52A.
Next week we cannot. Next week is a very short week.
Yeah. There's my lord, adjourn for 2 weeks.
Thursday week. Wednesday week. একটু দেখে নাও ওয়েডনেসডে উইকে নেক্সট
Well, the state was supposed to file a preliminary report about the claim of my juvenility.
My lord, we have not received the report today, my lord.
report be placed on record, adjourn 2 weeks. Other matters 2 p.m.
Your Lordship, may I be permitted to mention one matter for correction? Your Lordship, this matter of CRR 4076 of 2024. Until
For item 1 and 2.
Lordship, item for already.
My lord, I am for the appellant.
Actual rise appearing for the petition.
Mr. Chaudhary,
Lordship,
where is the state law here?
my lord, I had informed Mr. Luxam. Perhaps, my lord, he is on his legs before any of the court here, my lord.
Because we have not disposed of the appeal.
Lordship.
We have directed the matter to be remanded for additional evidence
Lordship. Lordship.
and adjourn the hearing of the appeal after the additional evidence is recorded.
Lordship. Lordship. Lordship.
Accordingly, I direct the trial judge to recall PWs 8 and 13 and examine them in respect of identification of the seized ornaments.
Lordship. Lordship.
2. Summon responsible officer from the service provider who is in charge of the device or its management which produced the CDR and CAF. Exhibit 20 and prove the certificate issued by him and prove the certificate in terms of section 65B4 of the evidence.
Lordship. Lordship.
Just to mention, appellant shall be permitted to cross-examine these witnesses and shall be
Lordship.
further examined under section 313 CRPC in respect of circumstances appearing against him from the additional evidence adduced.
Lordship. Lordship.
It shall be concluded within 2 months from the date of receipt of records of the case.
Lordship.
After the records of the case along with the additional evidence adduced will be transmitted to this court for disposal of the appeal in accordance with law.
My lord. My lord.
Right, that is why we needed to look some.
My lord, since he is not on the virtual platform now, my lord.
So please communicate order with
Lordship, I will do that.
Today.
I will do that.
Necessary steps are taken. All right.
I'll do that. I'll do that. I'm so grateful to you, Lordship.
Thank you. Our the party. Yes, call the list.
Item 1.
Accusation, Lordship. Not after the petition.
I'm for the
May I request your Lordship, my lord, to see, my lord, the last order of 25th of February of this honorable court.
My Lord,
Lord,
the
this is with respect to one of that matter, my lord, of the SC/ST Atrocities Act. What I said, my lord, that the dispute between the de facto complainant and the petitioners.
The inadvertent error occurred in order dated so and so. Miss Prita Pal, learned advocate, learned state advocate, is requested to appear on behalf. Learned advocate is appeared in place of এটা correct করলাম yes has the opposite party number 2 been served?
My lord, they are served, but my lord, I'm not ready with the affidavit of service. I do have the.
But they have to come and file a joint
My lord,
petition.
I also inquired, my lord, both the petitioner and
Alright.
the opposite party are my lord ill and cannot.
Let the matter appear as contested application 4 weeks since.
As your lordship, please. My lord, the report, your lordship kindly sees the report.
I see that.
Report is present. He has not accepted them.
I'm sorry, my lord.
So we are just keeping as a
As your lordship, please. As your lordship.
contested application, no stay.
As your lordship.
There shall not be any stay in the proceeding.
As your lordship.
Now the proceedings shall continue in the meantime.
As your lordship, please.
Next.
Grateful.
Item 2.
My lord, I am appearing for the petitioner. I had not mentioned this, my lord. It has come up for correction.
Next. 3.
My lord, I appear for the petitioner. My lord, the service is not complete. My lord, I pray for 2 weeks accommodation. My lord.
Let this matter appear as contested application 2 weeks since. 4 weeks since.
Grateful, my lord.
Next.
Item 4.
My lord, I am appearing for the petitioner. This is a supplementary affidavit. On the last day, we made the submission. The entire amount has been paid.
Achha.
400.
Supplementary affidavit enclosing payment of Provident Fund dues is based on record in view of the averments in the supplementary affidavit. I admit the petition, contested application 4 weeks hence. Copy of the petition be served, so and so, stay for 6 weeks or other.
Grateful, my lord.
Yes.
My lord, I am for the petitioner. My lord, on the last occasion, my lord, when your lordship was pleased to hear the matter, my lord, if your lordship kindly remembers that the petitioner is the in-laws of the opposite party number 2. My lord, 498A case has been filed by my sister. My lord, 125, DV Act, everything filed. Thereafter, they instituted 2 cases against us. It fell from your lordship that the... No, my lord,
It has not been settled, lordship. As per
No,
your
my
lordship's earlier direction, lordship, vehicle has been returned, but without
lord,
blue book, lordship.
My lord, we'll seize, my lord, I'm saying. My lord, if your lordship kindly sees page 9. My lord, the scooty has been returned. My lord, the scooty was purchased with my money. That transaction is there. As a Dahej, my lord, it was given to him. My lord, he has the blue book. Because it was purchased, I have annexed the challan as well. My lord, it was
whose name the
opposite party number 2.
So hand over the blue book.
My lord, it is with him, my lord. My lord, I have annexed the challan with as well. My lord, the scooty was there with me.
As per instruction, lordship,
I have returned.
along with vehicles, lordship, in the
All right,
custody of
obtain a second blue book.
My lord, I have handed over the scooty.
All right. Petitioner has handed over the.
Lordship, 2 case has been instituted by him, lordship, that is pending before the Honorable High Court, lordship. One in respect of
settle
498.
both of all the cases.
Lordship.
There is hardly anything. Family members. Petitioner has handed over the scooty.
My lord.
To the opposite party. This is admitted by learned counsel appearing for the private opposite party. In view of the aforesaid development, we direct the matter to appear as contested application 4 weeks hence. Copy of the petition be served upon opposite party number 1 through public prosecutor, High Court, Calcutta. There shall be stay of proceedings for 6 weeks or until further orders, whichever is earlier. Liberty to pray for extension.
But that supplementary affidavit be taken.
Supplementary affidavit.
Grateful.
So it is supplementary.
Lordship, I'm here, lordship.
Mr. Laksam, you pass.
Lordship.
Copy has been served upon you?
No, my lord.
Please give a copy.
Yes, ma'am.
Copy shall be served upon learned counsel appearing for opposite party number.
My lord.
Supplementary affidavit is placed on record, which discloses the alleged, which discloses the scooty has been handed over to opposite party.
Great.
Mr. Laksam, we have disposed of the appeal. We have directed the matter to be sent down to the trial court for identification, if any, of the ornaments by 8 and 13 and of certificate under
Civic.
65E by a
The
response.
Lordship.
All right.
Yes, Lordship. Yes, Lordship. Whatever suits Lordship. Grateful, Lordship.
Yes.
Item 48.
48.
And for the petitioning, Your Lordship, I'm praying for not to take, Your Lordship.
No, not. What is there?
No.
Why it should be cancelled?
Your Lordship, the opposite party is a local muscle man, and he has several antecedents, Your Lordship. And he's been, after getting the anticipatory bail, he's been threatening us.
Threatening?
And harassing
Where is the
us.
threat?
Just on the fact because we
Where
are
is the threat? Where
dog lover. You don't know, but Your Lordship would find that on page number. What should chat? Where are those? On 36, page 36, Your Lordship.
Page 36 is WhatsApp.
WhatsApp chat, Your Lordship. Just because I am a dog lover and I feed the stray dogs in the compound, in the housing complex, the opposite party is doing so with me.
What is the allegation that you were feeding dogs and they assaulted you? You let them give notice. You have given notice.
No, Your Lordship.
Give notice. Let them give notice. Huh? Copy of the application be served upon opposite party through registered post. Full stop. You are for the state. State shall.
Just now I saw it.
Shall submit a report with regard to allegations of threat and intimidation on the petition. Six weeks contest. 6 weeks. Next.
49.
49, my lord, I'm appearing for the petition led by Mr. Arun Kumar Maiti. On the last occasion, your lordship had asked the service. I'm filing affidavit of service today. The bail has been obtained by misrepresentation, my lord. The honorable bench which granted bail was led to believe that a civil suit was pending pertaining to the affairs of the partnership firm in the learned court below. However, no such suit has been pending. On that ground, the learned division bench granted bail. Moreover, my lord, the question pertains to a certain company which is Miss Vertex Buildings LLP Systems Limited, wherein a partnership deed was formed. The partnership deed has the fourth signature of the petitioner. That will be proven from the expert's testimony that has been provided in the case diary.
Accused person, they are not cooperating with the investigation.
Petitioner
So the
has assailed, order granting ancillary bail to opposite party number 2 in CRM A 5677 of 2023. It is contended the order was obtained on the premise. It is contended no civil suit is pending between the parties, but it was contended that order was obtained on the strength of incorrect submission that a civil suit is pending between the parties. Full stop. In fact, no suit is pending between the parties. It is also contended that the partnership deed,
We have obtained the expert report.
partnership deed, that in the partnership deed, the petitioner's signature has been forged. We have considered the aforesaid submissions. Crux of the allegation in the FIR is that the petitioners had forged the signature of the opposite party accused have forged the signature of the petitioner. Noting that The document was in the control and custody, alleged forged document is in the control and custody of the investigating agency. In such circumstances, the bench was of the view though progress of investigation may require comparison of specimen signatures with the
that they have come and given their signature that was obtained and expert report is there, the signature doesn't match.
কি বললাম with the forged signature, the bench noted custodial interrogation is not necessary and granted anticipatory bail. Good stop. And granted anticipatory bail. We are informed opposite party have given specimen signatures, and the expert report shows that the signature does not match.
My lord, the petitioner's signature does not match.
The court signature does not match with their signature. It cannot be said that
With the petitioner's signature. Petitioner has not signed in that document. Petitioner's signature does not
Have
match.
you compared the signatures of the have you compared the handwriting of the accused with the forged handwriting?
No, that is not.
Then have they given handwriting?
My lord, the forgery was only contended on behalf of the petitioner. That is why the petitioner's handwriting has been considered.
We are aware.
No,
but
that is not done.
Whether they themselves forged your signature or not.
That we do not know, my lord.
You do not know. That is why
Lordship, in that petitioner to asheni. They didn't. Petitioner's comparison.
কি বললাম যেন?
এই তো বললাম compare করো।
Now we are informed no steps have been taken to obtain the signature / handwriting of the opposite party number 2 accused. Under such circumstances, it is open to the investigating agency to take necessary steps in that regard, if so advised. Stop. However, bearing in mind the nature of accusation and the profile of investigation, we are of the opinion no interference. We are of the opinion the order granting anticipatory bail is neither perverse nor does it call for interference. Next.
Petitioner in this matter. Now, this is a case, my lord, where anticipatory bail was granted by this honorable court on 21st of August 2024. My lord, there are two conditions. First condition is that, my lord, he will meet the investigating officer till the conclusion of the investigation. And the second condition is that, my lord, he will not leave the jurisdiction of North 24 Parganas. In spite thereof, my lord, in clear violation of the court's order, he left the jurisdiction on 11th of July. He went to Agartala.
Where is opposite party?
My lord, service was affected on the last occasion.
Officer in charge shall notify the opposite party with regard to pendency of the proceeding
appear করেছিল তো?
And next date of hearing.
They appeared on the last occasion.
Who?
অর্ডারটা আছে?
Amita Go.
appeared for this.
State.
Lordship was pleased to call for a report.
Nondini.
Man.
Who appeared?
No, for the
Wakalatnama file. No Wakalat file.
appear করলো তো আগের দিন।
It is adjourned.
Who has appeared?
No.
Nobody has appeared. Officer in charge shall notify the opposite party number 2 accused with regard to pendency of the proceeding and the next date of hearing. He is directed to appear personally or through his learned counsel on that day. Adjourn 2 weeks.
Should I place on the record of his violations?
We petitioner contents opposite party number 2 has violated the conditions
But the report
of
is filed by us.
State submits reports. Full stop. Nobody appears for opposite party number 2. Therefore, it is
Grateful. Thank you, report. My lord, can I pray for a copy of the report?
Later on, let them appear.
Right.
Lordship, it's the matter of the cancellation of bill, Lordship. In 7/9/2024, the charge sheet has been submitted, Lordship. Pre-arrest bail granted by the Section Judge Purva Midnapur on 28/11/2024. Lordship, kindly consider the injury in this particular order in last page.
We have considered the material. Petitioner assails order dated so and so, granting anticipatory bail to opposite party. He contends that the gravity of the offense and the nature of injury had not been considered. We have produced the order granting anticipatory bail. The judge considered details in the case study, including the injuries injuries appearing from the injury report. Petitioner de facto complainant contend that he had suffered fracture injuries, but no such allegation is there is no such allegation in the FIR, either in the FIR or in a subsequent statement. This dichotomy, noticing this dichotomy, learned judge was inclined to grant anticipatory bail. Order is an well-reasoned one and does not call for interference. Application is dismissed.
And for the petition lordship, my lord. Petition lordship, my lord. The petitioner was, my lord, she was married on 26th November 2023, my lord. And thereafter, she went with her husband to Mumbai, my lord. And she was compelled to leave the city. She was harassed in many ways, my lord. That compelled us to come to Calcutta on 30th of November, my lord. And thereafter, my lord, she was harassed and she was tortured. That compelled her to make complaint on 20th June 2024, my lord. Thereafter, she was assaulted. She was admitted to the hospital, my lord. And thereafter, my lord, they made an application for anticipatory on 26th of 11, 2024, my lord. And she was harassed in many ways, my lord, which compelled us to file a petition, my lord. That has been disposed of on 7th of February 2024. May I give the copy of the orders, my lord? Read course, my lord.
Petitioner has prayed for cancellation of anticipatory bail granted to opposite party husband. He contends that the learned judge failed to consider the fact that the petitioner had been tortured at the matrimonial home and her Stridon articles had been tortured at the matrimonial home. She was assaulted and had to be medically treated. Investigation was done in an investigation was not conducted properly. Petitioner was constrained to take out petition under Article 226 of the Constitution of India, and directions were passed therein full stop. Accordingly, she prays for cancellation of bail. We have considered the materials on record. Petitioner was married to opposite party number 2 1 year ago. Matrimonial dispute cropped up, full stop. It is alleged petitioner had been subjected to cruelty and had been assaulted, full stop. Learned judge considered the materials in these issues required may be assessed at the appropriate stage of the proceeding. Learned judge considered the materials in the case diary and noted that Stridon articles had been recovered. Under such circumstances and in view of law declared in Arnesh Kumar so and so, we are of the opinion no worthwhile purpose would be served in committing the opposite party number 2 in custody. Accordingly, we find no reason to interfere with the order granting answer. Next.
For the petitioner, 498-406 letter added section 316 of Indian Penal Code. Well, this is second application. The learned code below, Malad has taken note of that fact, and then Malad granted bail. Malad kindly come to the impugned order once.
Was not pressed.
Yes, Malad, not pressed. Malad, it's a second application, Malad.
Because it is not pressed. On merits no disposal.
Malad, you could see that how it has been dealt with. No change of circumstances within 43
Yeah,
days.
but petitioner contends that
And my lord,
order that the opposite party number 2 withdrew an earlier application praying for anticipatory bail. Immediately thereafter, another application was filed
before vacation means.
and the same was allowed. He prays for cancellation of the bail. We have considered the materials on record. Opposite party number, there is a matrimonial dispute. Opposite
My lord, the medical evidence has been collected.
opposite party number 2 is the husband of the petitioner. In the FIR, it is alleged petitioner was subjected to cruelty. As a result of physical assault, she had miscarried. Full stop. Learned judge considered the medical evidence on record and opined that the said evidence does not indicate the
No, my lord, it has been collected.
The said evidence does not indicate any role of the petitioner's role of the accused in the miscarriage. Full stop. In view of the aforesaid, the order granting it may not be out of place to note the earlier application for pre-arrest bail was not disposed of on merits but had been withdrawn as not pressed. Under such circumstances, we do not find any jurisdictional error to any error, far less jurisdictional error, to interfere with the order granting anticipatory bail. Application was fixed. Next.
57. Lordship, this honorable court has been pleased to grant anticipatory bail to the opposite party number 2 and others. Now, in court premises when the date was fixed for commitment, in court premises the present opposite party number 2 used filthy languages. 195 case has been registered. I have also mentioned.
Extremely sorry. Actually, I was leading him. I thought it was the next matter.
You are sleeping behind.
I thought it was the next.
Oh, he is not saying that you are leading him.
I also was.
So how are you? Some other matter.
না 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 এইটাই দাদা ব্রিফ এটাই দাদা তুমি করো আমি জানি না আমরা তোমাকে সরি
Who is instructing you?
I was briefed by the victim.
You cannot be briefed. You are a senior
The advocate on record of the victim.
Who is the advocate on record?
My lord, Dhananshri Biswas.
So if she is not there, you cannot appear. Let us hear. Then whom have you briefed, madam? Huh? Whom have you briefed? Mr. Chatterjee? Then if you brief Mr. Edulji, then you have not briefed Mr. Edulji. Then Mr. Edulji, who has briefed?
Kindly make this note today.
Not today, not this week. Let this be clarified.
Led by Mr. Ujjwal Remand.
Here on behalf of respondent number 2, my lord.
Who are you?
My lord, I am the
accused number, accused.
We
Lord, the-
cancel your cancel your bail.
However, my lord, kindly consider my aspect also. We have got no notice. However, could not reside in our home.
Who
when
granted you anticipatory bail?
My lord, it is opposite party number 2, my lord.
Who granted?
My lord,
Page 38.
this honorable court, my lord.
This honorable court granted. Why are you asking for cancellation?
My lord, I tell you, my lord, what happened here, my lord, is the
Page 41.
page 30, page 41, my lord, is perhaps a my lord, I tell you the facts, my lord, very shortly, my lord. My lord, the petitioner before your lordship, my lord. My lord, the petitioner before your lordship, my lord.
All right. Yes, madam. Appear. Give
My
a
lord,
copy to
I'll serve.
give a copy to Mr. Dotto.
My lord, I'll.
File a report with regard to misuse of liberty.
Lordship.
Page 41. Petitioner submits opposite parties had misused liberty and threatened witnesses. He lodged complaint with the SP, Jongipur Police District.
And
And
we have got bail also from the.
now we will cancel this bail.
My lord, kindly consider this is the old enmity between the families, my lord.
Old enmity has resulted in murder.
And so many person has been granted bail.
Old enmity has resulted in murder. You were lucky to get an anticipatory bail. Now your old enmity is again getting the better of you. So you need to be put under some restraint, which is annexed at page 41 of the petition. State shall submit report with regard to the authenticity of the allegation. Learned counsel for opposite party number 2 shall file affidavit in opposition within 3 weeks. Reply, if any, 1 week thereafter. Matter will appear 4 weeks hence.
Grateful.
This is 58, no?
নামটা লিখে দিন হ্যাঁ
Next.
নামটা লিখুন
Yes.
My lord, I am appearing for the petitioner.
Very good.
On 26/9/2024, my lord, anticipatory bail granted, my lord, the opposite party number 2. From 2022, my lord, out of 10, only 3 anticipatory bail has been granted. After that, 7, my lord, they are showing absconding. And these Honorable High Court directed to investigate by the CID.
Let
And
the
after that,
investigation
my
by
lord,
CID.
2 additional.
That is the order granting.
My lord, order, my lord, last. My lord, that is
Last.
impugn, my lord, 2 page. My lord, on
Which
20.
order?
No, my lord, last 1 and 2. My lord,
What?
impugn order that is on 26/9/2024.
26/9/2024.
9/2024.
CR put up. Application for bail. That is application for bail.
Yes.
Bail.
Application for anticipatory bail.
26/9/24 application for bail. ACJM Baruipur.
My lord, your lordship.
Bojo. Dekho. Challenge here. Application is not in form. Dismissed. Liberty to avail appropriate remedy in accordance with law.
My lord, certified copy of the.
Certified copy be returned after replacing the same with a photocopy. Yo, यहाँ पे
51.
61 my lord, rule has been issued against me.
What is the case?
My lord, what has happened? My lord, allegation is that I, along with other persons, my lord, has beaten up a certain person.
Beaten up?
Beaten up. My lord, not murder, my lord. Beaten up. My lord, thereafter, my lord,
See why we issued rule.
my lord,
Vicky, our anticipatory bail order, this was rejected.
yes, my lord. My lord, your lordship would kindly come to
You
page
are
number,
for Vicky.
my lord, Rintu.
Rintu Singh.
Rintu. My lord, kindly come to,
Vicky, what happened?
my lord, kindly come to,
What happened to Vicky?
Vicky's antecedent bail, my lord, rejected by the
Rejected.
honorable court, my lord.
Then what happened to you?
My lord, thereafter, my lord, he has not, I think, my lord, he has not surrendered before the court, my lord.
Huh?
My lord, he was, I think, my lord, he not surrendered before the court, my lord.
Oh, what about the innocent minor police officer? Juvenile? What did he do? Hiked his rate. If our rejection of anticipatory bail is so toothless, then why trouble him? To give commercial advantage to dishonest police officers. What steps have been taken against Vicky Singh, whose anticipatory bail was rejected?
And then, my lord, I shall take.
Yes, please file a report 1 week. Their detention. Why do you require their detention? We don't do theoretical activity here. We do something which touches on a very important part of a man's life. And if we don't see the prosecution and the investigator not really requiring arrest, why should we deny liberty? And why should you oppose if your police officer does not take steps for arrest? Next.
62.
My lord, petitioner is the wife, my lord, who married to my lord, civic volunteer of Chandraguna police station. And that police station is investigation authority. But my lord, they had filed, my lord, started a case, my lord, under section, my lord, 498, 323, 325, 307, 406, 420, 34 BN Act of the Indian Penal Code. But when the bail, my lord, filed by the my lord, principal accused, my lord, under BNS Act, it is recorded BNS Act, but my lord, order 18B, my lord, where the landed PP have given consent for granting bail in favor of civic volunteer. Page 18B. Our landed advocate and PP raised no objection against the bail prayer. Since his civic volunteer is managed.
Managed?
Yes, my lord. And my lord, that police station where he is working, the principal accused.
The husband and wife, then?
My lord, my loan has been taken in the name of wife.
Very good.
Wife, but fraudulently taken the entire amount.
Very good. Petitioner submits she is the wife of the opposite party number 2 accused.
Well, after the
opposite party number 2 accused is a civic volunteer. Public prosecutor did not oppose the without consider the opposite party number 2 had fraudulently taken loan in the name of the petitioner without considering the nature of the crime. He without considering the nature of the crime,
My lord, IPC, but in the order it is stated BNS Act.
very bad. Is that the ground for cancellation?
Well, after the bail, my lord, is sending to
Copy of the
withdraw.
application be served upon opposite party number 1 through registered speed post, 2 through 1 through public prosecutor, registered speed post. Matter will appear 6 weeks hence. Let him come.
My lord, grateful. Grateful to the Lord.
Petitioner, Lord. This is cancellation because of the reason, Lord, the two brothers, Lord, the complainant and his brother. Lord, they have raised voice about the gambling in the locality.
So,
the brother and the petitioner both was, Lord, mercilessly assaulted. Now, Lord, thereafter, Lord, he initially
any post bail conduct.
Lord, but they are threatening me. Lord, kindly allow me a second, Lord.
If they are threatening you, go before the judge and pray for.
No, Lord, the writ, I have also initiated a writ petition. What has happened, Lord, in this case?
Then get it cancelled in the writ
No,
petition.
kindly.
If bail can be granted, bail can be granted.
Lord, here,
Under
facilitated
Article
it. The police
226.
facilitated it.
Under Article 226, bail can be granted. Then bail can be cancelled.
Lord, at the instance
Why
of
not?
the, no.
Go to the writ.
Lord, it has been disposed of.
Place the application.
It has been disposed of.
Then file another petition.
They have come up, the state has come up with a report saying this, they have prayed for, Lord, addition of section 112 of the BNS because of the reason, Lord, the pretty, Lord, organized crime was not there. Lord, what has happened in this case is that the medical report that was withheld and that was not placed before the learned judge. The police was instrumentality in facilitating the bail. That has came in the report.
Very good.
So, Lord, your Lordship would kindly allow me to, this is first time, Lord, kindly allow me to serve. Kindly allow me to serve, Lord.
Copy of the petition be served upon opposite party number 1 through public prosecutor, 2 to 5 through registered speed post with acknowledgement due. Matter will appear 6 weeks hence.
Fine. Lord, liberty may be given to file a supplementary affidavit.
No liberty grant.
Obliged.
65.
My lord, in item number 65, my lord, I am appearing for the petitioner, my lord.
Yes.
My lord, this is an application for cancellation of bail, not anticipatory bail. Not anticipatory bail, my lord.
Release due to lack of determination.
I'm grateful, my lord.
Bail এখানে তুলে দিচ্ছে কেন?
Matter was moved on 24th December 2000. Your lordship were directed to OC Jayanagur to communicate the petitioner mother. The matter will appear 7 January. OC Jayanagur notice 4th January at 2 evening. 4th January. At the time his mother is not prepared. Petitioner was abducted at Canning Station and 11.
Petitioner is the victim, is the mother of the victim. She contends notice with regard to the pendency of the anticipatory bail application was served upon her after the order came to be passed. She did not have an opportunity to oppose the application. Copy of the application be served upon opposite party number 1 through public prosecutor, opposite party number 2 through registered speed post. Matter will appear 6 weeks.
6 weeks.
Next.
Now for the petitioner.
Yes.
My lord, the opposite party has been granted anticipatory bail on 13th of December 2024, my lord, and after being released on anticipatory bail, my lord,
Number 71, my lord. I beg to appear for the petitioner that the opposite party number 2 has been granted anticipatory bail in an offense of murder only on the ground that charge sheet has been filed.
Copy of the petition be served upon opposite party number
and prime accused
1 to
undergone
public
substantive.
prosecutor, 2 to registered speed post, file apparatus.
Grateful.
Six.
So, 72. Plan for the petition. The page 11 is the order, my lord. At the time of granting anticipatory bill, my lord, he promised to pay maintenance for 15,000 rupees. 15,000 rupees per month is not paid.
His petitioner has assailed the order granting anticipatory bail on the ground that opposite party had undertaken to pay rupees 50,000 per month as maintenance allowance. It is tried law. It is tried law. A condition directing payment of maintenance allowance cannot be imposed on an accused while granting anticipatory bail. Non-compliance of such direction, in our estimation, would not justify cancellation of anticipatory bail. Application is dismissed.
Ditch. 73, my lord, I am for the petitioner. This is the application for cancellation of bail, my lord, and appearing for the
Not
first time.
for is lack of
74. Petitioner was threatened several times.
My lord, I am for the petitioner applicant, my lord.
You are appearing yourself or through Mr. Prahlad?
Myself, my lord.
You are appearing yourself. All right. Copy of the application be served upon opposite party number 1 through public prosecutor and opposite party number 2 through registered speech post file affidavit.
Grateful.
Not impossible. 30. Who's there? To be mentioned Monday. All right. Well, mother. Let's become a mother. Chicken. 31, 32. Huh? দুটোই to be mentioned all. We want to do these two death reference, 2018 death reference. So let us finish these two, see who are there. We are keeping it to be mentioned. Not this week.
But I'm appearing in for one of the appellants.
All right, we have got two. First,
My lord.
let us finish, then we will go to
My lord.
2019. 2018, there are two death references. We'll finish it, then go for now.
My lord, grateful, my lord.
Not this week.
137 and 138.
পুরোটা করো 137 to 152 153. Not this week.
Item number 149, my lord, has to appoint us this debt reference. Appeal has also been covered by the appellant.
Very good. We'll take it up when we take it up. These are 23. Let them wait. Let us finish 18 and 19.
One 54 to 174.
Not this week.
175 to 195.
Below 175, 176, and 177. Below there are these appeals. Below they are in custody. Below about 8 years. If your lordship any date fix, so please.
To be mentioned Wednesday. Let me see who are the appellants.
My lord.
Then we will
175 I'm appearing.
Yes, wait to accept. Both bar. Yes.
Where is it? Tuesday.
One 196, 216.
My lord, 201, my lord, the appellant is in custody for more than 6 years. My lord, any date your lordship kindly fix up this matter.
Not now. Not this week.
My lord, to be mentioned.
Not now.
My lord, kindly, my lord.
Later on. Not this week.
217, 237.
Not this week.
238, 256.
Not this week.
232, my lord. They are in custody for last 5 years, my lord.
5 years now.
If my lord, the matter be fixed, my lord.
10. Near about 10. Next.
257, 276.
The 262 and 263 I'm appearing on behalf of the appellants. One of the appellants is in, he has faced custody trial. So
not this week.
177 to 297.
Same.
278, 292, lordship.
Next.
298, 390.
Not this week.
300.
320, 338.
Not this week.
340.
339, 359.
Not this week.
357, my lord, I am not read for any suspension of sentence, custody, my lord. Appeal of my lord 2022 during trial. I would kindly any day may be fixed.
How many years are you in custody?
My lord, the case of 2016, my lord, from 16 custody. 2016.
2006. 9 years.
About 9 years.
302.
Yeah.
Wednesday to be mentioned. Tuesday to be mentioned.
357. 357. Nando.
Now, who is for state? Tuesday to.
40 lordship 20 years.
Huh?
I am in 20 years jail.
Oh.
340 Tapos Biswas.
340, you are in 20 years?
Yes, lordship.
20 years in custody?
Yes, lordship.
When did you get into custody? When the case, when the offense was committed?
20 years ago.
20 years ago?
Yes.
When? Where is your paper? Let us see.
I have, lordship also heard this matter.
How did we hear this one?
I have also given the written notes earlier.
Tapos Biswas?
Yes, lordship.
This is a conviction of 2022. When was he convicted?
Tapos Biswas.
Appeal of 22.
Appeal has been filed as latter stage.
Why? Why?
As because he is helpless. Nobody is helping him.
What about the legal services authority? They were not helping him.
About 22 years he is in jail, 22 years.
All right, to be mentioned,
Lordship,
Wednesday.
Lordship.
Not this week.
382, 398.
Not this week.
Regarding item number 267, my lord, NDPS matter out of 10 is in custody near about 8 years, my lord. Kindly please send it.
We'll consider. Take out an application for suspension.
Rejected, my lord. This prayer for suspension sentence was rejected.
When?
In 2019.
Now we are encouraging you to take it out.
My lord, 384, I'm for the appellant, my lord.
So, which year you have filed the appeal?
My lord, 2023, 2020.
Wait, rest, take rest for some time.
My lord, out of 10 years, I'm in custody for 7 years and 4 months. My lord, it is NDPS case. My lord, he was arrested with 170 grams of
So
cocaine.
the fact that you were
Yes, my lord, only
convicted
the,
does not mean that you should be immediately given
my lord,
liberty.
only that the gazetted officer was a part of the raiding team and
So
he headed the raiding team.
So what?
My lord,
From where the recovery was?
my lord, from his my lord, from his body, my lord, from his possession.
What is possession?
My lord,
From
no,
bag.
not a bag, my lord, from his pocket, because he was a Nigerian national. My lord, he dropped to the airport. There was a source information. He got into the cab. My lord, then he was apprehended.
Let us see. We'll wait. We'll see.